is for the speakers to convene the necessary committees and, using Article 125, summon the president to come and give evidence of 150 million from Isiolo, summon the president to give evidence of 10 million on anti-money laundering bill, and to give further evidence that he has. That is how the constitution that we have is drafted. And that is a challenge we are putting out to the speakers, not to protect parliament, but to ensure that for the good of the public, the very gross allegations made by the president can be investigated and the public can also get closure, because there are clear mechanisms for resolution of unethical conduct.
If speakers don't know how to do it, they can borrow a leave from Mother Kome, the head of judiciary. And I think the institution, then they have a responsibility, a duty of care to protect. Chair, this protection is important because you need to operate in an environment that you feel safe.
Correct.
It cannot be that anybody who wants to invade Parliament, they have a free day, to do what they want to do. No, the speaker must be able to say, you know what, we draw the line in the sand.
Correct.
This is how far you can go. Beyond this, if you have something to say about Parliament, there are procedures to say.
So I think our message is that as Parliament, we are open to scrutiny.
Yes,
and that scrutiny
is the point.
Must be done in accordance with the constitution we have, not the constitution that we wish to have. That scrutiny must be done in accordance with the Parliamentary Powers and Privileges Act, which has given the speakers certain powers to deal with unethical conduct. And we want to challenge all those who are making allegations, that we can even have a formal and proper inquiry. And we also want to challenge the president. If you know these people, do not be mourning and crying like every other common person. As a consumer of raw intelligence and as a person who can direct the DCI to carry out investigations, please, Kenyans want action. We have had enough talk. Let there be action on the parts of perpetrators of unethical behavior. When it comes to the institution of Parliament, the speakers must stand up.
Escape this accountability session, because he knew very well, Chair, that if he would have appeared before this committee, even I've looked at the responses, and I'm happy, Chair, you did direct that they were responses. I've read through the responses. He could not account for it. He could not account for it. So, Chair, I think finally on the observation that the issue of governors appearing, Chair, I take a very different approach, because yesterday I was laughing in a forum where we were including, you saw me laughing in devolution, is because I know there is an Oparanya case and the courts have litigated on this matter, and once and for all, governors must and should appear before the Senate and before the Parliament. Article of the Constitution says any committee of the Parliament has the power to invite or summon any witness to assist in the investigations.
The Supreme Court was very clear, and we can even, Chair, we can even buy a full page in the newspaper and give a summary of that decision so that the message is out loud and clear. The highest court under Article 163 is the Supreme Court. There is no any other place you can go to seek a different interpretation than what the Supreme Court of Kenya has provided.
Governors are the ones who are misadvising Mzee, because you remember when we had a meeting with the party leader in the Senate, when he came out of that meeting, the pronouncements he made, including strengthening the place of Senate in order for devolution to succeed, those were the proper words or the proper advice that Jacom gives. And I know his mind. I know his position on devolution. He's the father of devolution. I was very shocked to hear some of those pronouncements, because I know he's been misadvised. Number two, Honorable Chair, I know that Article 96 of the Constitution places upon us the responsibility to oversight